What if I told you a client walked into my office with a $500,000 tax bill 90 days from trial after his first representative had already tried everything? And then he walked away owing nothing, not a reduced settlement, it wasn't a partial win, it was zero. And here's the part that surprises most people. None of the facts changed. Nothing new was discovered. The case didn't get any stronger, it just got presented differently. This is one of the clearest examples I've seen in my career of a principle that applies to almost every IRS dispute. It's not just about being right, it's about proving you're right in a way the IRS can actually act on. So let's set the scene. My client, I'll call him Michael, he owned a logistics company. Not a struggling business, not a shady operation, a profitable company that had been running successfully for over a decade. Then Michael's tax return got selected for a routine IRS audit. But unfortunately, routine didn't stay routine for long. The examination resulted in adjustments that added up to a proposed tax liability of over $500,000. For context, based on Michael's business, that wasn't a number that just hurt. It generally threatened to potentially shut his business down. Michael's original CPA, whom I'll call Paul, and he was a capable guy, he handled both the audit itself and the appeal that followed. Paul did everything by the book. He'd been preparing Michael's returns for about a decade. The record keeping was there, the substantiation was there, but despite Paul's best efforts, that administrative appeal went nowhere. No meaningful reduction. The administrative process, which, by the way, in most cases, resolves the vast majority of IRS disputes, had been fully exhausted and it hadn't worked. So that left one option, which was tax court, litigation. And Michael's case had been filed there and was already on the calendar less than 90 days from trial. And that's when he called me. But here's where the case gets interesting. When most attorneys inherit a case 90 days before trial, they start building a trial strategy immediately. You may have to take depositions, aren't as common in tax court cases, but they sometimes happen. But there's things like expert witnesses, courtroom arguments, potentially some motions to file. That's the instinct. But I did something different. Before doing anything else, I went back to the beginning and reviewed the entire case file from scratch. And what I found was a pattern I've seen over and over again in tax controversy work. Michael's positions on his tax return were legitimate. His documentation was solid. Paul had done thorough, competent work for years. Everything was accounted for paper somewhere in the file. The problem wasn't the substance of the case. The problem was that the information had never been organized or presented to the IRS in a way that let them say yes. You need to think about who's actually reviewing the cases on the other side. Revenue agents and appeals officers are people, and they're people with heavy caseloads, limited time, and a stack of files on their desks that all look the same. If your case shows up as a disorganized pile of receipts and scattered explanations, even a legally strong position can get buried and overlooked. These IRS officials need, and frankly deserve, a clear, logical presentation of the facts and law in order to reach a favorable conclusion. Michael's case had simply never given anyone that chance. And that realization changed everything about how I approached the next 6 weeks. Instead of immediately preparing for trial, I took a step back and rebuilt the case from the ground up. First, I worked with Michael to track down additional supporting documentation, records that existed but had been overlooked or just never fully utilized during the original audit and appeal. This wasn't about finding new facts or the smoking gun, as they say in criminal trials. It was about finding the facts that were already there but never made it into the file in a usable form. Second, and this was the real work, I reorganized everything into a single comprehensive package. Not a folder of disorganized documents, it was a narrative. Something that told one clear, compelling story explaining exactly why the IRS's proposed adjustments were incorrect, backed to every point by the underlying evidence and the law. And this is a subtle but important distinction to make. Most taxpayers, even some professionals, think of an IRS defense as, here are our documents, you figure out how they fit together, but it's all there. That's exactly backwards. Your job is to do that work for the reviewer, show them the connections, make the conclusion obvious before they even finish reading. We submitted that reorganized package to the IRS counsel roughly 6 weeks before the scheduled trial date. I felt good about our legal position, but I want to be honest about my expectations at the time. I braced for a long negotiation. I was hoping for a partial settlement. That's usually the realistic outcome, even in a strong case. But instead, I got the email every tax controversy attorney dreams about. IRS counsel came back recommending full concession of the case. The entire $500,000 proposed liability was reduced to zero. No trial needed, no further negotiation. For all practical purposes, it was as if the audit never happened at all. And this is the whole point of the story, and I want to make sure I repeat it so it's clear. The facts hadn't changed whatsoever. The documents hadn't changed. Paul's original work wasn't wrong. What changed was how everything was organized and presented, and that difference was worth over $500,000. So what's the takeaway for you if you're facing an audit, an appeal, or even a case headed towards litigation? First, don't assume your case is dead just because your first attempt at resolving it failed. Michael's case had already gone through an audit and a full appeal with an experienced CPA, and it still hadn't worked. That doesn't mean the underlying position was weak. Sometimes it means the case simply hadn't been presented in a way that lets the IRS agree with you yet. Second, presentation is not just a cosmetic detail. It's a substantive part of your defense. Two taxpayers can have exactly the same facts and get completely different outcomes based purely on how clearly and persuasively that information is organized and communicated. If you remember nothing else from this video, remember that. And third, and this connects to something worth knowing more broadly, court is almost always an option when the administrative process doesn't get you where you need to be. Michael's case was, in fact, on the tax court calendar. Litigation is a real and available path, and sometimes it's necessary. But it's also expensive, time-consuming, and uncertain, which is why it's generally treated as a last resort rather than a first move. In Michael's case, we never had to set foot in the courtroom because the reorganized presentation resolved everything beforehand. That's the outcome you're always hoping for, using the threat and preparation for litigation as leverage while resolving the dispute you actually have before you have to go through with it. So if you're sitting on an IRS notice, an unresolved audit, or a case where your first round of appeals didn't go the way you hoped, don't assume the door is closed. Sometimes the strongest case in the world just needs to be told differently. I'm a former IRS revenue agent, and I've seen this from both sides of the table. If you want to talk through your situation, feel free to reach out, and let's figure out together how to build your strongest case. So if you enjoyed this video, found it helpful, please subscribe for more real stories from inside IRS disputes, and I'm excited to see you in the next video.